I'm also speaking to these amendments, and I thank Senator McDowell for clarifying, and I think it's important that there is unity across the House in relation to the database, that's not affected by this, and I think there are a number of other areas of common agreement across the House, but I do also have to oppose Amendments 7 and 21. And I will speak to why. It is to that core issue, which is persons' rights to have their story told if they wish to own their own words and own their own experiences. When we look to the 2004 legislation, the 2004 legislation was drafted at a particular moment in time. I would say Ireland was early enough in beginning its journey towards, we were previous to certainly things like the referendum and the rights of the child. We were previous to the apologies. We were previous to Tuam. We were at a point where we were beginning to look to these stories. And there was still an assumption, and it's an assumption that permeates many parts of our legislation, things over the history of this state, unfortunately, of a climate of secrecy and of a climate of an assumption of secrecy. So be it. Nonetheless, the 2004 legislation did have a measure which allowed for balancing. In it, it said it allowed commissions may be conducting things in private unless a witness requests that all or part of his or her evidence be heard in public and the Commission grants the request. So there was that proviso, which allowed that people should be able to give their evidence in public if they wish to, unless there was a reason not to. And one of the only reasons that maybe perhaps not to were where there was concerns that the Commission may have concerns in terms of impacting with the procedure and the investigation. Again, bearing in mind the records we have now, the investigation is finished and concluded. The procedures are concluded. So that was 2004. But let's go to the 2015, to the order establishing this commission. And it reflected to some extent the fact that the argument and the situation and understanding had changed. So in fact, under this Commission's order of establishment, under Part 4B, it said it would provide in its procedures for individuals who wish to have their identity remain confidential during the conduct of the Commission and subsequent reporting. The assumption has switched from we assume everything is private and you might request public to actually saying it may be public, but of course, and there are times, and I think they've been very eloquently described by Senator Boyan, there are circumstances, and must be circumstances, where people should be able to request to speak in private. That was the mandate that was given to the Confidential Committee. The Confidential Committee were asked to provide in their procedures for individuals who wish to have their identity remain confidential. However, the Confidential Committee instead issued instructions to people that told them it would be private, that told them it would be secret, that in fact specifically refused. And we have indeed the chair of the Confidential Committee speaking to the fact, the director of the Commission in fact speaking about how a number of groups had asked for public hearings, and specifically because this Confidential Committee, this is the testimony, this is what happened, this is the word of those affected. But she said that at least 5 individuals had asked to give their evidence in public and had been refused. Now I care about those 5 individuals and I care about their rights. And I know that there are far more than 5 because a number were told from the beginning that it was going to be this way. This is how it was going to be. It was not based on volunteering. People were not looking for assurances in many cases because they were not ashamed. They were proud of themselves. They were proud of themselves for coming forward and talking about the horrors that had been inflicted upon them. And it was a huge moment for people to be brave, to come forward and talk about their experiences. And they wanted it to be recognised. And they wanted the dignity of it being recorded. And they wanted the history books, which had hidden them after decades of erasure and secrecy, to show that they had stood up and given testimony. And we know this from the histories of abuse. We know this from court trials on sexual abuse and attacks, how important it is to be able to say, I recovered my power and strength and I gave my voice and I spoke and I reclaimed my life and experience. And I think I would say with great respect to Senator McDowell, It is not something that you can casually be phoning up Joe Duffy about, or that you might write to the paper. And people do not. The Senator may have access to RTE or to the Irish Times as he wishes, but it is not something that most have. And I know that I've had people coming during the interim, when we were halfway through this process, I had people phoning me, begging me to read what they said into the Shannon record, because they were so upset that what they said had vanished, and it is a thing. It is not easy to give this testimony. It is not easy to give it multiple times. It is not something you want to run to the media, but you want the record to show it. So absolutely, we must have a huge nuance in this. I don't believe that these records should be transferred wholesale to, and therefore, and I think, in fairness, Senator McDougall acknowledged there are provisios in our National Archives. It would be entirely inappropriate if that were to be the case. Absolutely, those who wish to be anonymised, so forth, should be, documents should be, but there must be space left within this legislation. And that's why, Minister, in relation to the operation of Section 41, I have an amendment later where I ask that you would make regulations in terms of how the 30-year would operate. And those regulations should indeed include provisios that protect the anonymity for those who actively want anonymity and offer an opportunity for access to their own testimony, and indeed an opportunity to not be erased from history for those who do wish to have their records. One of the very few people who did manage to get their public story out is Philomena Lee. Her family are tweeting today again about how important it was, how much she wanted it to be in public. She challenged and begged for her record to be in public. And there is, again, a legacy. The culture that prevailed in 2004 and around those times seemed to have trumped the very real direction that was given to the Confidential Committee in the 2015 order. And if they have chosen to, in fact, not properly give people the right to the option of public at that time, we certainly should not replicate that mistake. And I would moreover point out there's two specific concerns here. One is that the record would lost and that people would disappear. If there's one thing we've known, is the disappearance. If the records are not transferred, the stories of persons would vanish. I don't think that that is a respect to people, and I think it is not. And I would moreover, those who wish to have their names in their stories, not simply to be a salutary lesson for the future generations, but to be known as their actors, that they should have that right. Again, my amendment at a later stage, it does seek to address this issue in a different way, but what it does is it suggests that all of the data protection rights, including right to erasure, if that's what people need and want, as well as the right to access your own personal information, should be applying in terms of all of the records, including those testimony pieces of the Confidential Committee. So I have huge respect for those proposing, and I know that, but I cannot support these amendments.